Assalamualaikum warahmatullahi wabarakatuh. My name is Dania Wardina binti Azlan and I will be the first speaker for the proposition team. The topic assigned for today's debate is the Federal Constitution has established an effective and efficient mechanism for checks and balances in Malaysia to prevent corruption, nepotism and cronyism being practiced in the country. I will be arguing in favor of the topic with my first argument, that is, the doctrine of separation of powers is implemented in Malaysia. The doctrine of separation of powers is a fundamental principle in constitutional law that seeks to distribute governmental powers among separate branches of government to prevent the concentration of power in a single entity. While the doctrine is often associated with the political systems of countries like the United States, it also has relevance in Malaysia. Malaysia follows a constitutional monarchy system with a parliamentary democracy. The doctrine of separation of powers in Malaysia is not explicitly enshrined in a single constitutional document, but it is implied through the Federal Constitution of Malaysia and the principles of constitutional interpretation. In Malaysia, the three branches of government are the executive, legislative and judiciary. Each branch has distinct functions and powers. The executive branch is headed by the Yang di-Pertuan Agong, who is the constitutional monarch, and the Prime Minister, who is the head of government. The executive branch is responsible for the administration and enforcement of laws. It includes the cabinet, which consists of ministers appointed by the Prime Minister. The executive branch exercises executive powers such as implementing policies and managing the day-to-day affairs of the country. The legislative branch is responsible for making laws and is represented by the Malaysian Parliament, which consists of two houses, the Dewan Rakyat, House of Representatives, and the Dewan Negara Senate. The Dewan Rakyat members are elected by the people, while the Dewan Negara members are appointed. The legislative branch enacts law, approves the national budget and scrutinizes the executive's actions. The judicial branch is independent and is responsible for interpreting and applying the law. The highest court in Malaysia is the Federal Court, followed by the Court of Appeal and the High Court. The judiciary safeguards the rule of law, protects individual rights and resolves disputes. It acts as a check on the executive and legislative branches by ensuring that their actions comply with the powers conferred to them by the Constitution. The Federal Constitution does not explicitly mention in its content that the doctrine of separation of power applies in the Federation. However, it can be observed in several of its provisions. For example, Chapter 1 and Chapter 2 of Part 6 of the Federal Constitution deals with the distribution of legislative powers and executive powers respectively. Meanwhile, the powers of the judicial bodies can be found in Article 121, in which this article establishes the judicial power and independence of the judiciary in Malaysia. It states that the judicial power of the Federation shall be vested in two high courts, the Courts of Appeal and the Federal Court. It also emphasizes that judges shall be independent and shall be subject only to the Constitution and the law. A significant case that demonstrates the doctrine of separation of power is the case of Semenyih Jaya Sdn Bhd against Pentadbir Tanah Daerah Hulu Langat and another, in which this case involved a dispute over land acquisition. The Federal Court of Malaysia highlighted the importance of the separation of powers and emphasized the executive branch cannot interfere with the judiciary's decision-making process. The court stated that the executive must respect the independence and integrity of the judiciary. Another case that is relevant to the debate is the case of Teh Cheng Poh against Public Prosecutor. The said case dealt with the power of the judiciary to review administrative decisions. The Federal Court held that the judiciary has the authority to review and scrutinize administrative actions to ensure they comply with the law and adhere to the principles of natural justice.
Assalamualaikum everyone and greetings. I am from the proposition teams and we are in believe that the Federal Constitution has established an effective and efficient mechanism for checks and balances in Malaysia to prevent corruption, nepotism, cronyism that has been practiced in our country by way of judicial review. So, the judiciary is an independent separate body. It is be able to check and balance between the executive and legislature. By Order 53 of Rules of Court 2012, any person who is affected by a decision made by the public authority shall be entitled for judicial review. In the case of Jail Island, the High Court has quashed the decision made by the executive, as it was believed by the minister has not exercised his power in accordance with law. This is in line with Article 8 of the Federal Constitution, which everybody is equal to law and everybody shall be entitled to be treated equally before the law. Same apply in the case where a person is unlawfully detained. In the case of Vishnu and Lelaki Telagan, the person was unlawfully detained under preventive order, and the court decided to order for habeas corpus, as the court believed that the minister did not carefully examine and analyze the material facts before delivering such order. This is in line with Article 5 Clause 2 of the Federal Constitution, where whenever a person is said to be released whenever he was being detained unlawfully. In the above-mentioned case, that showed that whenever there was a miscarriage of justice in one body, another body shall interfere to ensure that there was justice that needs to be prevailed. To conclude, we believe that the Federal Constitution has established an effective and an efficient mechanism for checks and balance in Malaysia to prevent corruption, nepotism, and cronyism being practiced in Malaysia by way of judicial review. Thank you.
We, the opposition team, once again support for today's motion, where the Federal Constitution has established effective and efficient mechanisms for check and balance in Malaysia. Apart from the existence of judicial review, Malaysia owns several independent bodies that will assist the government in deterring any corruption, nepotism or cronyism in the country. These institutions ensure that the government is held accountable and the power is not concentrated in one branch. For instance, our country has the Election Commission, Suruhanjaya Pilihan Raya (SPR), which is responsible for overseeing elections in Malaysia. It also ensures that the elections are free and fair and the result is accurate and transparent. This statement can be proven by referring to Article 114 Clause 3 and Clause 4 of the Federal Constitution, where it shows that to be a member of the Election Commission is not an easy path to pass. They need to fulfill the requirements that stated in Article 114 Clause 3, and they also can be removed if they found guilty by doing those restrictions in Article 114 Clause 4. So the objective of this commission is just for ensuring fair and equitable operations in undertaking the elections. Other than that, we also have Malaysian Anti-Corruption Commission, MACC, an independent, transparent and professional body to manage the nation's anti-corruption efforts. The function of this commission can be clearly understood under Section 7 of the Malaysian Anti-Corruption Commission Act 2009, where one of it is to receive and consider any report of the commission of an offence under this Act and investigate such of the reports as the Chief Commissioner or the officers consider practicable. Next, we refer to the case of Public Prosecutor against Rosmah Mansor, where the accused was the wife of the former Prime Minister, Datuk Seri Muhammad Najib. She was accused of corruptly soliciting and also receiving gratification as an inducement and reward for helping a company in getting a project from the Ministry of Education. This case is best to refer to as it involved the wife of former Prime Minister Datuk Seri Muhammad Najib, and here we'll not discuss the case in detail, but by mentioning the case is just to show that everybody is not above the law regardless of the status of the person, and to prove the transparency of the MACC in investigating a case and to gain the trust of the public.
The independence of the judiciary can be viewed as the power or ability of a judge to decide the case based on their merits without being influenced by any external factors. So in essence, it's applied the court must be independent and free from fear and favoritism. So to begin with, concerning the constitutional allocation for superior courts, the Federal Constitution guarantees that the separation of institution between the superior courts and other branches of government. So the superior court possess independent status in theory and remain separate from both the legislative and executive executive branch in practice. So the formation of the courts, the organization framework, and the power and membership of the judiciary and the regulation governing the judicial conduct are established by legislation, and they are safeguarded against interference by executive branches. So first of all, the Constitution guarantees that the independence of judiciary through the consultation process for judicial empowerment. It is imperative that any nomination for a judicial position undergoes an extensive and multi-stage coordination phase involves various stakeholders. So the provision in Article 128B and 122B and 123 address the process of the appointing judges and the minimum qualification required for the judges in high-level court. Furthermore, the Federal Constitution incorporated reasonable standard as well. According to Article 123 of the Federal Constitution, specific prerequisites are outlined for the selection for the judges for the Superior Court. It is required that the candidate to be a citizen and have minimum 10 of years legal experience in practicing law at bar. So in other words, in order for the qualified to be appointed as a judge, one must fulfill all the criteria and cannot be appointed without any merits. Furthermore, concerning the tenure of the service, the judicial personnel are often more appealing service and remuneration compared to the civil servant. By the virtue of Article 126, the judges' salary are charged on the consolidated fund. Additionally, with regard to the transfer, as outlined in Article 122C, the Chief Justice holds the authority recommended to transfer the judges between High Court, subject to the approval of the YDPA. Next, the judicial body is excluded from political affairs. Most legislation shield the court from political negativity. So under Article 127, Federal Constitution restricts parliamentary debates on the action of the judges except on the ground of substantive resolution endorsed by more than fifth of the judicial representative. It is illustrated in the case of Raja Sekarang and Bar Council. Judgments are restricted to be debated in Parliament. Pursuant to the Article 125 Clause 6 of Federal Constitution, compensation of the judiciary shall be paid by the consolidated fund, thus removing it from the budget debate. Lastly, the authority to take action against stands of contempt. It is granted to the judiciary by Article 126 of the Federal Constitution. Issue of contempt of court are illustrated by the case of T.O. Thomas and Asia Fishing Industry. This power is not limited to any specific individual and any extent to every citizen, including prominent figures as the Prime Minister, Attorney General and other members of the government.
Hello, Assalamualaikum. My name is Samir Lokman and my matric number is 2119149, and I will be the first opposer which will be against the motion given. So now I will first deliver the definition of check and balance. So the doctrine of separation of powers involves a system of check and balance. Each branch of government is given specific powers of oversight, check over the other branches of government, and powers to restrain the actions of the other branches of government. The aim is to ensure a balance of power between the three arms of government. Okay, next I will move to the part which regarding the importance of judicial independence, which are the mechanism to ensure check and balance. So one of the importance is that the judiciary supplies the balance wheel of federalism. It has a duty to safeguard human rights by balancing the might of the state with the rights of the citizens. Judges interpret the constitution to harmonize conflicting provisions, to make explicit what is implicit in the law, and to fill the gaps found in legislation. They provide remedies whenever rights are infringed. Also, the judiciary is an essential component, though not the only one, of a system of check and balance. It is a safety valve without which no democracy can flourish, and for these reasons, judicial independence must be safeguarded. Integrity and ability must be rewarded, and respect for judicial decisions must be maintained. The judicial branch must be separate from and independent of the other branches of the state. So the issue that will be highlighted here is judicial independence was eroded through several ways, including contempt of court. Article 126 gives power to punish any person who by word or deed interferes with the administration of justice or challenges the dignity or independence of the court. The interference includes corruption, threat, financial problems, executive interference, and secrets which are embarrassing. There are executive defiance in which the court seem to be reluctant to impose this power against them. So, in 2000, referring to the case of Adorna Properties, Sdn Bhd and Bonsum Bunyanit, a shameful decision legitimizing the transfer of stolen land was delivered, and it took about a decade to set things right. In the Lingam Gate Royal Commission report and subsequent litigation, evidence was put forward that a senior lawyer was in cahoots with a senior judge to recommend the judge for a coveted award. There is a story about a lawyer sponsoring the holiday abroad of a CJ. There was scandalous news that in the case, the judgment was composed by the lawyer involved in the case. So that's all from me. Thank you and Assalamualaikum.
Nepotism, or also known as favoritism, aka preferential treatment of relatives and friends during hiring process, regardless of others who might be more qualified for those positions. A very famous example of Rupert Murdoch, the owner of one of the largest media companies in the world, is a fairly well-known case of nepotism in business. Despite having dropped out of college, his son James Murdoch has been employed by the corporation for a number of years and was on the board of directors of News Corporation before resigning last year. The degree level necessary, the number of years of work, and other formal education are all tight requirements for moving up the corporate ladder in a setting as large as this. Murdoch Jr. would have been a fantastic match for the position based on the talent he developed over the years, but basic qualifications would have prevented him from ever being allowed to join the company long ago. Now, nepotism in Malaysia nowadays famously occurs in political field. Although there has been a law impliedly prohibiting the practice of nepotism, in Malaysia, for instance, Section 23 of Malaysian Anti-Corruption Commission Act 2009, MACC, any officer of a public body who uses his office or position for any gratification, whether for himself, his relative or associate, commits an offence. For the purposes of subsection, an officer or a public body shall be presumed until the contrary is proved to use his office or position for any gratification, whether for himself, his relative or associate, when he makes any decision or takes an action in relation to any matter in which such officer or any relative or associate or his has an interest, whether directly or indirectly. Despite having such written law in Malaysia, due to weak enforcement of law, nepotism has already been a culture practiced by almost majority of Malaysians, especially three organs governing Malaysia now, namely judiciary, legislative as well as executive. Nurul Izzah's appointment is a well-known example of a recent occurrence of nepotism. The appointment of Prime Minister Anwar Ibrahim's daughter, Nurul Izzah, as his senior advisor on economics and finance has drawn criticism from a variety of sources, with detractors claiming it stinks of nepotism. Nurul recently disclosed to a local news outlet that she has been acting as an advisor on economics and finance since January 3rd. The announcement outraged social media users who labelled the appointment as nepotism, a practice among persons in positions of authority or influence of preferring family, friends or allies, notably by providing them employment. Although Nurul's father made it clear that she is not employed in any capacity, the general public claimed that the practice would only permit similar appointments in the future. Another example is how Khairi Jamaluddin, the son-in-law of former Prime Minister Tun Abdullah Ahmad Badawi, came under fire after being named as his close advisor. Additionally, there was opposition to the appointment of Miss Nurul Hidayah binti Ahmad Zahid to the board of the government organisation SME Corporation in January 2021. She is the daughter of UMNO President Zahid Hamidi, who was named Deputy Prime Minister in December. Another occurrences of nepotism is due to the Lim family's monopoly over the DAP. Nepotism already exists and will only get worse. With the numerous positions Lim held during the course of his 51 years in politics, it is well known that DAP advisor Lim Kit Siang is in command of the party. Due to the occurrences of nepotism still arising rapidly in Malaysia, we, the opposition, strongly oppose the motion set before the House and conclude that the motion shall not be passed. Thank you.
Assalamualaikum warahmatullahi wabarakatuh, and greetings to the honorable judges, the proposition teams, ladies and gentlemen. My name is Abdurrahman Amnan and I will be the third speaker for the opposition team. Before we start, my team will once again emphasize that we strongly object the idea of today's motion, which is the Federal Constitution has established effective and efficient mechanism for checks and balance in Malaysia to prevent corruption, nepotism and cronyism. As for my part, I will further explain on the system of check and balance which did not prevent the crime of corruption in our country. First of all, we need to know the definition of corruption. So, corruption is a type of dishonesty or a criminal offense committed by a person or organization in a position of authority in order to obtain unlawful benefits or abuse power for personal gain. Such in case of PP against Datuk Haji Harun bin Haji Idris, Raja Azlan Shah, Federal Court Judge, discussed the word corrupt and referred to the case of Lim Keng Kui against R, which stated that corrupt means doing an act knowing that the act done is wrong and doing so with evil intention. Hence, we use the primary legislation which governs the bribery and corruption in Malaysia, which is the Malaysian Anti-Corruption Commission Act 2009, MACC Act, which was enacted to provide for the establishment of the Malaysian Anti-Corruption Commission to make further and better provision for the prevention of corruption and for matter necessaries thereto and connected therewith. Despite the implementation of MACC Act to fight and prevent corruption, it does not affect this criminal offence from being spread wide across the country. Politicians and public authorities seems not really care and aware about the act, and corruption still happens publicly in front of our eyes. Hence, I prepared some occurrences of corruption in Malaysian context. We can further look into the case of the Sabah Water Department, 1MDB cases, Port Klang Free Zone, and also Immigration Department scandal in the last 5 years that occurred in our country, which illustrate how corruption and bribery are deeply embedded within Malaysia's political and government institutions. Corruption cases in Malaysia include bribery, extortion, fraud, embezzlement, blackmail, illegal gambling, laundering, and nepotism. All of this which encompass the abuse and misuse of public power and authority. This includes public officials taking or offering bribes through money or service which is dishonest. And then, I also prepared the case of Datuk Seri Muhammad Ajib bin Haji Abdul Razak against public prosecutor for us to further look into the matter of corruption, where in this case, Datuk Seri Najib was charged under Section 23 Clause 1 of the MACC Act for gratifying himself to the tune of 42 ringgit million by participating in the Malaysian government's decision to guarantee 4 billion loan from the country's pension fund to a newly incorporated private limited company, in which Datuk Seri Najib himself had an interest. He was later convicted and sentenced to 12 years in prison and also had 210 million fine in lieu of 5 years in prison for the aforementioned offence. Hence, this proved that the non-independence of the judiciary leads to corruption. To conclude, corruption in the judicial system violates the fundamental concept of equality before the law, depriving citizens of their right to a fair trial. Money and influence may dictate which cases are prioritized or rejected in a corrupt legal system. Perpetrators may go unpunished, leaving victims with no answers and no justice. Hence, I end my discussion with thank you and Assalamualaikum.
We disagree with the motion. It's because Malaysia has yet to establish an effective and efficient mechanism for check and balance in Malaysia in preventing the occurrence of nepotism, corruption, cronyism. I will be arguing on the occurrence of cronyism in Malaysia. So I'll briefly explain the definitions of cronyism. According to the Cambridge Dictionary, cronyism is the situation in which someone important gives jobs to friends rather than to independent people who have the necessary skills and experience. In simple terms, cronyism is when a person appoints their friends or close relative towards a certain position regardless of their qualification. So, as an example, law enacted under Article 10 Clause 2A, which is Official Secret Act 1972. This is a law which deals with the classified documents owned by the government on matters which are confidential. Once the document is classified as an official secret, the document cannot be made public. Only authorized persons are allowed to have information about the documents. The Act does not require them to justify what the document should be an official secret. Some of the hideous acts were protected under this law, as example, bribery, cronyism, nepotism, and others. So we are talking about occurrence of cronyism in Malaysia. Cronyism in Malaysia is a big topic of discussion. There are many occurrences in Malaysia that can be seen throughout the years. Some occurrences happen because their act was supported and blinded by the law. As an example, members of the public will never know to whom the tender was given. It could be their close relative or even their family's members. Once it was marked as confidential or secret, no one has authorization over it unless themselves. As an example, former Lord President Saleh Abbas admitted officials had tried to bribing him to leave the judiciary quietly because he did not want to compromise the independence of judiciary. Muhyiddin and members of Bersatu received 300 million from contractor awarded project during the pandemic. So how exactly non-independence of the judiciary leads to cronyism? So in simple terms, it is not the matter of non-independence of judiciary body, but it is more to the power vested in them. How could there be justice when the judiciary was appointed by executive body as stated in Article 122B of Federal Constitution, which talk about appointment of judges of federal courts and court of appeal and high courts. So we strongly believe that there is no separation of power, and due to that, all this kind of corruption, cronyism, nepotism, and any kind of it is still occurring here in Malaysia. So that will be from me. Thank you very much.
Assalamualaikum warahmatullahi wabarakatuh. My name is Dania Warina binti Azlan, and I will be rebutting the points given by the first opposition member on his issue that is the judicial independence has been compromised by conferring powers to the court to punish for contempt of court by virtue of Article 126 of the Federal Constitution. The opposition council is invoking Article 126 without knowing the limitations of which the law of contempt can arise. There has been no authoritative definition on law of contempt of court, but a definition by the Honorable A. Vijaya Lakshmi Venugopal in his textbook Contempt of Court in Malaysia can be cited, where the administration of the legal system or course of justice is interfered with or obstructed by any party in any way, such as through omissions, actions, gestures, and or comments. The first opposition member has failed to take note that Article 126 is not absolute and can only arise in certain circumstances. There are different statutes that govern contempt of court. For example, for Magistrates and Sessions Court, paragraph 26 of the third schedule of the Subordinate Courts 1948, for High Court, Court of Appeal and Federal Court, they will refer to Section 13 of the Courts of Judicature Act 1964 and Article 126 of the Federal Constitution, and for Industrial Court will be referring to Section 58, subsection 1 of the Industrial Relations Act 1967. Abdul Malik Ishaq Justice in the case Asia Pacific Parcel Tankers Pte Limited against the owners of the ship or vessel Norma Splendor 1999 6MLJ 652 held that contempt of court can be divided into two categories, which are criminal contempt, which consists of words or acts obstructing or tending to obstruct or interfere with the administration of justice, or the second category, which is civil contempt, which relates to disobedience of judgments, orders or other processes of the court. Examples of contempt of court may extend to failing to fulfill court orders, evading service of a court order, scandalizing the court, disrupting court proceedings, false statements, and likewise. To conclude my points of rebuttal, I would like to submit that conferring powers to the courts to exercise their power on the matter of contempt of court actually strengthens the position of judicial independency in Malaysia, as it ensures that the judicial body can work without the disruption of others. Thus, we submit that Article 126 does not compromise the judicial independence in Malaysia. Instead, it acts as a mechanism to ensure the judicial body can deliver justice to those seeking it. Thank you.
I shall rebut the argument raised by the second opposer, which cited a case of PP against the UMNO bahagian pekan to illustrate the occurrence of nepotism in our country. I shall start my argument by saying that such case did not portray the occurrence of nepotism fully. However, it portrayed a better implementation of doctrine of separation of power in our country. Let's say that if there was a lack of implementation of the doctrine in our country, such case was not be able to be taken in the first place. There will be no case to be tried at all, and the accused person shall never be ever charged with such allegation. This is different with another country. Let's take for example in India, to be compared with India, whereas almost 100% of the members of the parliaments in the lower house has a political background. This helped them to be in the parliament because in India, members of parliaments are elected based on the family lineage instead of merit. The children of parents who are political figures shall run for election based on their parents' ticket, not on their own strength. What is worse, this has happened for almost more than decades, and not a single body is there to interfere with this kind of occurrence in the country. This is a great example of nepotism rather than what was brought by the opposer in that case. In the end, the argument brought by the second opposer does not portray Malaysia as a country that has significant amount of nepotism occurrence, because there was a strict implementation of doctrine of separation of power to be compared what was happening in India today. So to say that there was occurrence of nepotism based on the case, it was not true, and it was a weak argument. Thank you.
I'll be deal with the third opposer's submission, where he raised the issue of corruption in Malaysia and in the judicial system violates the fundamental concept of equality before the law, which deprive the citizens' right of their fair trial. So the issue now is whether the system of check and balance in Malaysia is comprehensive or not. So the third opposer also raised the case of Datuk Seri Muhammad Najib, again public prosecutor, in order to show that even though there is laws or legislation in our country to prevent the corruption, some politicians and public authorities seems not really care and alert about the act, and corruption still happen. So we beg to differ on that submission, because we can take a look at some dictator countries where their form of government in which one person or small group possess absolute power without effective constitutional limitations. Those power can be used to save their malicious deeds, as they are the ones who control all the positions, either legislative, executive or judiciary powers. Meanwhile, Malaysia is a democratic country which practice the separation of powers. The opposition already knows about the existence of the establishment of MACC to prevent and prevent corruptions. This indicates that we have an independent body which is totally separate from the government to identify, investigate and charge every single person who violates the laws, especially in the corruption matters. It can be proven by looking at the mentioned case, Datuk Seri Muhammad Najib. Our former Prime Minister was brought and charged under Section 23 Clause 1 of the MACC Act to the court. So, regardless of the position of Datuk Seri Muhammad Najib as the former Prime Minister, MACC still investigate and charge Datuk Seri Muhammad Najib. In regard to our judicial system, the opposition said that the judicial system violates the fundamental concept of equality before the law. Such a claim is quite serious of accusation, because the opposition does not support their basis with any reported cases. Nevertheless, if there is immoral conduct of the judges being unjust, they are bound with Article 125 Clause 3 and Clause 4 of Federal Constitution, where there is a judicial tribunal appointed by the YDPA to investigate and to assist the issue. Therefore, we would like to stress that the system of check and balance of our country is already good enough, as the separation powers is clear and transparent.
So the fourth member of the opposition raised the issue that the Official Secret Act 1972, which was enacted under the Article 10, Clause 2, Paragraph A, create a room for abuse of power by the executive at worst to prevent the action of the government that was proclaimed as classified information shall not be questioned at all costs. They argue that due to this act, if the act of government are proclaimed as classified information by virtue of this act, it shall not be questioned by the parliament and the court, hence creating a loophole in regards with the doctrine of separation of power. By virtue of the Article 10 Clause 2b and 10 Clause 2a, the Parliament may impose a law notwithstanding with the Article 10 Clause 1a to restrict the right of freedom of speech if it is deemed necessary in the interest of the security of the Federation or morality. So by the virtue of Article 10 Clause 4, any law that was enacted under Article 10 Clause 2a shall not be questioned. So clearly, the purpose of the article and the act is to protect the security of the Federation and public order. So the issue are what the appropriate limitation of the disclosure and protection of national security interests, whether these restrictions are absolute. So in the case of Takong Tabari and Government of Sarawak, His Lordship Richard Melanjun in his judgment held that the Section 16A of Official Secret Acts, which affirmed that a ministerial certificate shall be conclusive evidence of official information, it did not prevent the court from inspecting the document in question under the Section 162 of Evidence Acts. The plaintiff in this case requested a court order to inspect the document containing a report of an person that killed her husband. The document were marked solid, confidential, and certified by the Director of Sarawak Public Works Department under the Official Secret Acts. So Justice Richard Melanjun said that the Official Secret Act is primarily intended to prevent unauthorized communication of official information that could or would likely harm the public interest or national security. So the law requires a witness to produce any document in their possession or power when summoned to do by the court. The court will decide whether or not the document is admissible and may inspect if it see fits. However, the court will not inspect a document that refer to affairs of state that were prejudicial to public interest. So in this case, the defendant argued that the document was classified as an official secret and therefore could not be disclosed. However, the court held that the classification of this document did not prevent it from being disclosed. The court also found that the document did not relate to the affair of state and that its disclosure would not be prejudicial to the public interest. So on Section 16A, His Lordship interpreted that the section does not prohibit the admissibility of the information classified as an official secret act. Section 16 merely prevents the questioning of the reason for classifying document as an official secret. Therefore, it is incorrect to invoke that the classification completely excludes it from being disclosed before a court. The court held that it was defendant showed nothing that the document related to affair of state or was shown of any procedural effect on the public interest by its disclosure. So in conclusion, by referring to the judgment that was proved in this case, the restriction is not completely absolute as long as the document or the matter is not proven to be related to affair of state. It then can be produced before the court. Therefore, if the court are satisfied that it is not related to the affair of the state, the court shall be able to produce or disclose it before the court.
Hello, honorable judges, opponent, ladies and gentlemen. Assalamualaikum. My name is Amir Rahman, and now I will give my rebuttal points that claimed by the opponent, whereby they claim that judicial review contributes enormously in checking and balancing the government and ensuring the government is prevented from any corruption and any other malafide. So my point is that we must bear in mind that there is an issue whereby the judicial refusal to review issues of constitutional politics. So, barring some honourable exceptions, our judges have demonstrated remarkable executive mindedness in a number of areas. Among them are ministerial discretion as opposed to police discretion under preventive detention laws, literal interpretation of austere clauses in some legislation like the Dana Harta Act, the 1MDB related cases, and many more. So the courts often evade or avoid their responsibility by resorting to technicalities to dismiss an application or pleading. Among the escape routes are federal court's power to refuse grant of leave, the doctrine of non-justiciability, the lack of locus standi, expiry of time limits, or failure to observe proper procedure. By referring to the case of Muhammad Juzaili Muhammad Khamis, there was a court of appeal decision in favour of cross-dressers who were suffering from gender identity disorder. They had successfully challenged the constitutionality of the state law, which subjected them to harassment and arrest, loss of livelihood, gender discrimination, and infringement of freedom of expression. Counsel for the defendant, the State of Negeri Sembilan, sought to avoid the substantive issues before the Federal Court by raising a preliminary objections that the case involves the Federal Court's exclusive jurisdiction under Article 4, Subsection 4, and should not have been entertained by the High Court or the Court of Appeal. This expansive view of the Federal Court's original jurisdiction was quite out of line with innumerable precedents to the contrary, including one in a case named Ahtian. So, hence, in any case, the jurisdictional argument was not raised on the grounds of appeal. Also, it had not been raised before the High Court or the Court of Appeal. Yet, the Federal Court bent over backward to entertain it, accept it, and censure the Court of Appeal's well-reasoned decision. The substantive issues were evaded, a learned judgment by the Court of Appeal was overturned, and the victims condemned to the status quo. Justice failed, and the Federal Court's reputation for impartiality and integrity suffered. So that's all from me. Assalamualaikum.
Good afternoon to the respected speaker, cautious timekeeper, honourable judge, members of the government team, and members of the floor. My name is Hanis Aina, and I am the deputy leader of the opposition. We are proving that the federal constitution has yet to establish effective and efficient mechanism for checks and balances in Malaysia to prevent corruption, nepotism, and also cronyism from being practiced in the country. I will now refute the Deputy Prime Minister's arguments, then I will continue with the second argument of the opposition for opposing the motion. Ladies and gentlemen, the proponent had stated that he agrees on the topic because independent bodies are said to have performed their duties and responsibilities to ensure check and balances in Malaysia. However, I, as the opponent, strongly oppose this resolution. I believe that check and balances in Malaysia is still ineffective and inefficient because of numerous independent bodies in Malaysia are no longer capable of addressing the problems of cronyism, nepotism, and blatant corruption. This also means that Malaysia's independent bodies now exhibit less openness or transparency, accountability, and good governance. Although it has a federal constitution and the MACC, Malaysian Anti-Corruption Commission Act 2009, this provision simply exists for the sake of rules and regulations that neither the legislative nor the executive branch any longer follow. Videos of the well-known president of the Parti Islam Se-Malaysia, or known as PAS followers, giving money to Terengganu voters make this clear. The cash disbursements, though they were referred to as donations, were really just another kind of corruption. Therefore, they could not be justified. Not to mention the fact that if other parties had employed similar tactics, the latter would have accused them of still corruption. Giving voters cash or other assets to sway their decision to vote or not is prohibited by Section 10 of the Election Offences Act. Associated independent bodies indicated above have not yet taken any action against them, despite the fact that the violation committed is expressly recognised. As the second proposer has indicated, I would like to finish by noting that I do not think Malaysia's check and balance system can be properly executed merely by looking at the qualifications of candidates or even whether the election results are fair and accurate. Independent bodies in Malaysia are urged to take immediate steps to strengthen their ability to combat cronyism, nepotism, and corruption, so that, should they continue, the entire nation will suffer immensely as a result of such heinous crimes. We disagree with the motion is because Malaysia has yet to establish an effective and efficient mechanism for check and balances in Malaysia in preventing the occurrences of nepotism, corruption, and also cronyism.
Assalamualaikum and greeting once again. I will be starting my rebuttal on the claim by the proposition team on the issue of independence of judiciary. Despite the federal constitution and laws containing a number of sterling safeguards for preserving judicial independence, it still has some unsatisfactory features. For the justification, first of all, for subordinate courts. To the ordinary citizen, the quality of justice is what happens in the subordinate courts. Regrettably, most of the safeguards for judicial independence are unavailable to the hundreds of judges of our sessions and magistrate courts. This should be a concern because 90% of criminal and 50% of civil cases are adjudicated at the lower courts. Secondly, on the defiance of a judicial decision, judicial independence has lately been compromised by officials in other agencies of the state. There are cases where habeas corpus was issued, and as soon as the detainee left the court, he was rearrested under a different charge. Often a law or an action is invalidated by the court, but the executive continues to rely on the invalidated law. Thirdly, for judicial corruption. Up till the 1980s, the Malaysian judiciary had a high reputation for integrity, but in the mid-90s, there was an anonymous letter accusing the Chief Justice and 11 other judges of corruption and grave improprieties. The issue was not officially investigated, and neither the author of the letter nor the judges targeted were investigated or prosecuted. And there are a lot of studies stating on corruption. This crisis will give birth to a number of other shameful tendencies within the top echelons of the judiciary, and it is painful to acknowledge these sad realities. To summarize my point, despite having a safeguard to preserve it, judicial independence still has many flaws that could not be prevented by the system of check and balance. The power vested in the judiciary was not enough to cater all the problems residing in it. Thank you.
Assalamualaikum. Very good afternoon to the respected speaker, cautious timekeeper, honorable judge, members of the government team, and members of the floor. My name is Hafiz Zainian, and I am the opposition whip of the opposition. We are proving that the Federal Constitution had yet to establish effective and efficient mechanism for check and balance in Malaysia to prevent corruption, nepotism, and cronyism being practiced in the country. I'll refute the opposition's argument, then I'll continue with my fourth argument of the opposition for opposing the motion. Ladies and gentlemen, the proponent has stated that he agrees on the topic because independent bodies are said to have performed their duties and responsibilities to ensure the check and balance in Malaysia. However, I, as the opponent, strongly oppose this resolution. I believe that check and balance in Malaysia is still ineffective, insufficient, because of we cannot say that Malaysia follow the doctrine of separation of powers, because Malaysia only imposed the doctrine of separation of powers partially. There are too many overlaps between these three branches of the government, namely executive, legislature, and the judiciary. So I'll explain briefly about the overlaps between legislative and executive. So in personnel, overlaps in personnel, YDPA as ceremonial executive. Parliament also consists of YDPA and two majlis. Minister and Prime Minister come from Parliament's House of Representatives and House of Senate. Based on Article 43, Clause 3 in the Federal Constitution, the Cabinet shall be collectively responsible to the Parliament. Both bodies are not independent of each other. The Cabinet is not answerable to the Parliament for its action. So, overlaps in its function is, in some situations, the Parliament will delegate the power of making law to members of Cabinet due to the lack of time. Minister come from Parliament, Minister draft the bill, then Parliament will support the Minister's proposal because they are from the same party. Article related to the function of the legislative and executive body is legislative body, which is Article 74 Clause 1 of Federal Constitutions, and executive body, Article 80 Clause 1 of Federal Constitutions, and legislative and executive body, Article 43 Clause 2A, 43 Clause 2B, and 43 Clause 3. So overlap between legislative and judiciary. So, however, there is no overlaps in personnel because judges are barred from becoming members of Legislative Assembly. But there are overlaps in the function. Judge cannot make law, but in practice, judge do make law through the doctrine of judicial precedent. Overlaps between executive and judiciary. Overlap in its functions. In terms of appointment of superior courts, YDPA appoint judge with advice of conference of ruler with Prime Minister. YDPA has power to give pardon. So there will be no overlaps in members because a member of executive is barred from becoming a member of judiciary and vice versa. With that being said, there is no separation of power in Malaysia to cater all these kind of corruptions, cronyism, and nepotism. With that being said, there is no proper distribution of power given in each body, resulting in overlapping power between them. The power vested in the judiciary was not enough to compare with the power vested in executive and legislature, of which leading to no independence in judiciary.